Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Honorable Justice Abdul Nazir and Vikramnath, while disposing the case of K.E. Krishnan versus K.E. Valsan, long name is there because I am wearing goggles, black glasses. I cannot tell the entire name. K.E. Krishnan versus K.E. Valsan in WP number 1464 by 2010. Of course, the decision was given on 13.6.2022. Stated that long cohabitation, please remember, long cohabitation between man and woman. So it may raise a presumption as though they lived as a wife and husband. And of course, you know, the children born to them, no doubt, if there is no legal marriage, we call them as bastards, and bastard son has no share in the property. But here, if the court presumes that the long-standing relationship, long-standing cohabitation between man and woman leads to marriage, then that can be called as a proper son, and he becomes a party to the, or he becomes a shareholder to the party. This is what happened in the case of K.E. Krishnan. So normally it is a civil case, but the application of section 114 of the Evidence Act is more essential. You have to read that section also in this particular case. No doubt. So there is an old man, K.E. Vaijanor or somebody, he has got some properties, he has got 4 sons, and out of them Mr. Damodaran is one of them. The other sons, they are all married. This Damodaran, he has got contact, or he lived with Chiruthakutty or Chimakurti, like that, some Karnataka, Kerala name, Chiruthakutty maybe. So he lived with her for a long time, and Miss Krishnan was born to them. And when the property is about to be distributed, this Krishnan filed a civil suit or suit for partition, but it was not allowed by the trial court as well as the High Court also. High Court also stated that there is no evidence to say that both Damodaran and this Chiruthakutty or somebody, they were married. No evidence of marriage. Then he becomes a son, by a bastard son. Of course, he should be treated like a son, but he will not have any shares in the property. This is what is observed by the Honorable High Court of Kerala, and agreed by the orders or judgment of the High Court. Now this man has tapped the doors of the Honorable Supreme Court of India. Here, Supreme Court of India, basing on the section 114 of the Evidence Act, clearly stated that if there is evidence to say that a man and woman, they lived for a long time together, there was cohabitation between man and woman for a long time, then it can be, a presumption can be risen that it's a marriage. If it is a marriage, the son born to the marriage, he is treated as though he is born out of wedlock, and definitely he is eligible for the share of the property. If you take in that line, definitely this man will have a share in the property. This is the opinion of the Honorable Supreme Court of India. Please remember, in so many other cases also, particularly in dowry harassment or cruelty cases like 498A, I have seen kitting of judgments by the Supreme Court that if a man and woman lived together in a house, and if the neighbors, they are under the opinion but that these people are wife and husband, then they are deemed to be married, wife and husband, right? So definitely the husband will come under the purview of section 498A of the Indian Penal Code, as stated by the Supreme Court in a great number of judgments. You may be knowing that. And please remember, similar is the case here also. Here, all the other brothers, 3 brothers, they were married, they had got their children, they wanted to apportion the property. But the only problem is, here, Mr. Damodaran could not officially marry this woman. So it has become a hindrance. Of course, here, this boy, Mr. Krishnan, was able to prove that both of them lived together, both of them cohabited, and there was a long-standing relationship between them. Therefore, basing on the evidence, the Honorable Supreme Court of India opined that it is presumed that they were married. So when the presumption is marriage, if any boy is born, definitely he is born out of the wedlock. So he has also got a share in the property. This is what is stated by the Honorable Supreme Court of India. Definitely please remember the case or read the case thoroughly, and definitely you will have such cases may come. So many people are there. Second marriage children, first marriage children, even persons who live in relationship, all these things. So if your only thing is you have to prove beyond all reasonable doubt that they live together, they live like wife and husband, then only this point will be useful, otherwise it becomes a waste. So that's why High Court stated that where is the marriage certificate, where is the evidence that they got married? No, then we can't help it. No doubt you are treated as a son, but no share in the property. But Supreme Court, in its wisdom, they held that no doubt they are not married. రకరకాల కారణాల వల్ల మ్యారేజ్ చేసుకోకపోవచ్చును. మ్యారేజ్ లేని మాత్రం ఇద్దరు కలిసి ఉంటే, భార్యాభర్తల్లాగా ఉంటే, చుట్టుపక్కల వాళ్ళంతా వాళ్ళని భార్యాభర్తలు అనుకుంటే అది వివాహం కిందే లెక్క. ఆ పిల్లవాడు వివాహం ద్వారా పుట్టినట్టే లెక్క. ఆ పిల్లవాడి కూడా దీంట్లో పార్ట్నర్షిప్ ఇవ్వండి అని చెప్పి Supreme Court చెప్పడం జరిగింది. 114 of the Evidence Act, please read it and read the case law so that you will be enriched with legal knowledge. Thank you very much.